My lords, I'm not going to read through it, but all I respectfully submit that it.
On the assumption that we have.
Yes.
But, I hope. I hope my confidence in your lordships is not misplaced. But,
I hope they're correct.
My lord, all I say is, and it may be uncontroversial, is that what that indicates is that both your lordship's board and appeal courts such as the Eastern Caribbean Court of Appeal with Justice Appeal Saunders have had regard to the norms established by the European Convention in interpreting the prohibition on inhuman treatment or cruel and unusual punishment, and have indicated that where there is a clear norm, they would wish to align their own jurisprudence with that of the major international instruments. I accept that it's not every twist and turn that has to be followed, but I do, my submission to your lordships is that there is a clear evolving norm in that series of cases which I showed your lordships, which is consistent with the approach of the Rome Statute, that there should be a substantive review of whether there is a penological justification for continuing detention, and that it should be governed by clear and accessible criteria.
It's interesting to see from this note and in the citation from Bow that in the Bahamas, the European Convention was actually part of their domestic law for 37 years before it became part in England and Wales, or 37 years before it became part of our domestic law.
Same is true in Trinidad.
I was going to say, what's the position about Trinidad?
Yes, Trinidad, yes, it's the same. It's, you see it at the top. And
It was a general application, wasn't it?
Yes, general application, yes.
To all Crown colonies in 1953.
My lord,
So for 9 years in Trinidad it was, until they had their own constitution. Which
yes, my lord, it's set out at, I'm so sorry, my lord, under Matthew and the State at paragraph 37, Trinidad became inherent, and then it, as in some other countries on the European, so there was a period when it was dependent. And then the Canadian Bill of Rights. My learned friend, Mr. Delzin, has asked me to show you a case of Francis and other in the state of Trinidad and Tobago. Can I just indicate there is a very scholarly derivation there of the Constitution in Trinidad and the very careful consideration which was given to the adoption of the Canadian model. And it was something into which there was the input of distinguished local jurists. De la Bastide Woodwing, I mean, about the most eminent jurists.
Paragraphs?
Well, I'm afraid, my lord, it's paragraphs 28 to 156 because it's a very scholarly. But I'm not going to. Although Mr. Delzin would like me to read the whole thing.
Paragraphs,
But my lord, it explains that there was very careful consideration of what model should be adopted, and it was the local Trinidadian Bar Association which was urging the adoption of the Canadian model, and that therefore this isn't a case of just some civil servant saying this is what we're going to do. This was input from the local Trinidadian distinguished jurists that's the option they wish to have. My lord, but I do submit that therefore, particularly in the area of what constitutes inhuman punishment.
So they're taking actually, it's very interesting, they're taking a strong issue, I see, with the decision of this board in Surat.
Yeah.
Where Lord Bingham dissented, of course.
Yes, ma'am.
And
well, my lord, I would love to get into it, but all I want to establish.
We are keen that we.
Yeah, I'm sure you're keen that But my lord, I do say that therefore, if there is a clear evolving norm, and I respectfully submit there is, that there should be a rule-based review, particularly where when the life sentence is imposed at the start on a mandatory basis, then that if your life sentence lacks that elementary safeguard, then I do respectfully submit that it's a cruel and unusual punishment. Now, the remedy may be to say that such a safeguard must be instituted rather than to invalidate the sentence, because you have the widest powers of remedy. But I do submit that is a norm that can be derived not just from the European jurisprudence, but from the decision in Power and Lichniak, from the Rome Statute, and from really reasoning about what is just and appropriate. Indeed, looking at the colonial system itself, where clearly issues where you had been commuted to life, the two issues which were considered was, had you done enough to satisfy the requirements of retribution and deterrence in the individual case, and then was your release justified? That's been the approach of the English and colonial authorities for many decades before that.
Can I just ask you some information about the status of the European Convention pre-independence? In most, if not all, former overseas dependencies, the 1953 order effectively applied the convention. But was there legislation in force? I mean, that obviously conferred the status of a treaty on the convention in those jurisdictions, which of course is a limited status under the common law. My understanding is that in none of the Caribbean jurisdictions was there actually legislation to give effect to the treaty, or am I wrong about that?
Well, I think that there would have been an internal Bill of Rights even under the colonial government, which would have incorporated similar provisions. Certainly I know that in Belize, for example.
Well, similar provisions, but would it actually have required effect to be given to the convention?
No, it just would have repeated.
As such?
No, it would have repeated the words of the convention, and it would be, in other words, under letter.
No equivalent of Section 6.
No, my lord.
There would be the presumption that the organs of the state didn't intend to act in a manner inconsistent with the international obligations.
Yes, my lord.
But that's the limit.
So it would be like England pre the Human Rights Act, my lord. Yes, but with this one exception that I'll check for Trinidad, but in most of the pre-independence regimes, if I can call them that, there would have been an internal Bill of Rights.
There is in the United Kingdom. As there is in England.
Yes, but it's slightly more extensive. I mean, modelled on the European Convention, yes.
In similar terms?
Yes, in similar terms, yes. And that would have been under, I think, under an order in council. My lords, my learned friend started his proposition by saying that there could be no conceivable criticism of what was done in 1993 and 1998 because the court followed what was recommended in Pratt. I do respectfully submit that that's just simply inaccurate. Pratt never recommended that someone be ordered to be detained during the whole of their natural life, which was what was done in this case. Now, it may be that injustice, with all the uncertainty and anxiety.
Irreducibly?
Yes.
Pratt did recommend the substitution of a sentence of life imprisonment.
Life imprisonment, but not natural.
The addition of the
not the addition of the words natural life, which the Trinidad courts have declared to be an impermissible addition or
effective addition.
Yes, an ineffective. But the fact is they didn't follow Pratt because they added that, and then there's the addition and shall be detained throughout his natural life.
But
so
what does that add to the word life imprisonment?
Well, 10 years on, we know it adds nothing. Or 15 years on, we don't know. They didn't know that at the time.
Did they not? Why do you say that?
Because, my lord.
What did they think it meant at the time?
Well, it was struck down by court after court, and you have them annexed, where the court said there is no such sentence as sentenced to the rest of your natural life.
Was that on the footing that they were reading for the rest of your natural life as meaning irreducible upon review?
Yes. Yes, and creating a presumption that in Power and Lichniak that you will be detained for the rest of your life without a review of some internal tariff, as it were. But the second point I make is that without any doubt, the 75 years were not following Pratt and Morgan. Pratt and Morgan gave no authority and no recommendation that you substitute 75 years. If we look at the 75 years, which took place under the Attorney Generalship of Ramesh Lawrence Maharaj, one can see that behind that there would have been an intention, because you've seen the cases about it being, life being too soft, as it were, to make something stiffer than life, because it was regarded as 10 years, as you've seen in the case law. And
something less easily reduced.
Yes, exactly, my lord, exactly. Now, the moment you liberate yourself from the proposition where we're just doing what Pratt tells us to do, which is to substitute life, and you select a penalty, one, you can't say we're just doing what Pratt does. Two, you must, in our respectful submission, have a regard to whether that's a proportionate penalty for all the cases, irrespective of their merits, to which you impose it. And they didn't do anything of the sort. You've seen that in 17 cases within 4 months, and you have some of the facts of some of the cases which are before you, they impose the same undifferentiated penalty. We say that would be, even on the merits of the time, because there'd be no individual consideration of the merits of a very, very substantial penalty, cruel and unusual. And in the de Boucherville case, there is a consideration of a mandatory 45-year sentence for drugs cases in a case called Philibert, where the Mauritian Court of Appeal held that that would be inhuman and had to be, it would be a violation of the right to a fair trial and had to be set aside, and that's approved in de Boucherville by your Lordship's board. So we do respectfully submit that it's not the case that the starting point is that they didn't do anything wrong. The starting point is that they did do something wrong. Not only did they not give them a fair hearing, and although Reckley decided that it was unreviewable, the mercy, it didn't decide that you can be unfair. It just simply said if you are unfair, there's nothing, it can't be reviewed. So we respectfully submit the starting point is that an injustice was done for which, it being a legal injustice, there's a right to a constitutional remedy. And then, my lords, we come on to the point about if you have a right to a constitutional remedy, we say that right is not extinguished by the exercise of the prerogative of mercy. And my lords, I know I've summarised my case. My learned friend has given his reasons, but can I just make this point? In Pratt, at the top, I think, of page 403, it said, we have the power to substitute an appropriate term of imprisonment. And that's, so in the exercise of our constitutional remedy power, we have the power to substitute an appropriate term of imprisonment. Now, that's your Lordship's board in a case of delay. Then in Hunt and Khan, which my learned friend glided over, your Lordship's board said again that, indeed, you not only said it, but you said that that's the only remedy to go by way of constitutional motion. And you overturned an earlier case of Ramdeen on the basis that there was an established remedy. So it's at volume 2, tab 24, an established remedy for delay, in delay cases of going for a constitutional redress. So, my lords,
What paragraph is that?
So it's paragraph 61 of Hunt and Khan, so tab 24. So paragraph 61. Yes. Yes. Paragraph 61. In the present appeal, the respondent's mounted a frontal attack on Matthew as a precedent. That's to say the state did. The parties have helpfully provided the board. The board's statement that it had jurisdiction under section 14.2 to set aside the mandatory sentence by analogy with Pratt seems to have been made without the benefit of any argument. It was not the real point in that case, and there may well have been. It is certainly the case the judgment itself contains no clear explanation of the board's reasoning, then the fuller arguments, and then paragraph 68. Secondly, the issue concerns the constitutional power of the judiciary to interfere by way of appeal with a lawful sentence. If the board is persuaded that it has taken to itself a judicial power which it does not possess, it would be damaging to respect for the rule. This point is not weakened by the fact the board would have jurisdiction to interfere with carrying out the sentence on an appeal from a constitutional motion under section 14.2, because that is a procedure for which provision is made by the Constitution. In other words, twice in Pratt and Morgan, and then in Hunt and Khan, where it was the ratio of the case that there is a remedy, a proper remedy, by way of constitutional motion, it has been said that a person who wants to complain about delay not just has the right, but ought to make the complaint by way of constitutional motion, and then there is that remedy. Now, if your lordships were to now say that there isn't that remedy, but instead the only remedy is by way of going to the for mercy, we respectfully submit that that would be completely back to front. There's one thing is quite clear, is that the power under section 87 was not devised to meet situations where your rights have been violated, but to meet cases where, as a long stop measure, a residual power to mitigate a penalty imposed by the law.
You haven't yourself looked at the state of the state's printed cases in Hunt and Khan. They've wisely instructed different counsel to argue the present case, but I suspect you would find lots of statements in those written cases asserting the existence of this jurisdiction.
Yes. I mean, now we have, all of a sudden, my learned friend saying, not only is there an alternative, which is a residual discretion in section 87 to kind of, as it were, make up for other defects, but that that's the preferable thing to what your Lordship's Board have twice said exists and should be exercised.
Have we got, amongst all this material we've now collected, any examples of the power that you say exists and Mr. Knox doubts exists being exercised?
Kirk and Thomas. Yeah, Andy Thomas and Kirk, that was one of the grounds.
Which one?
The Andy Thomas and Kirk, even before Pratt and Morgan, delay and prison conditions were brought in a constitutional motion.
Yep.
And on that basis, the death penalty was set aside.
In which case?
Andy Thomas and Kirk. I handed it to you, I think, loose leaf, my lord.
Thomas and Kirk.
Thomas and Kirk.
Oh.
Sorry, Andy Thomas and Kirkland Paul, that's right, yes.
Sorry, when did you hand it loose leaf?
I don't think we have got that.
Yes, I did. Yes, I did, my lord. It was the one which says 10 years is the average. No. And life means...
I know it exists. I'm not sure you...
I'm saying...
No, you did.
Yes, this one, yes.
10 years is... Yes. But I mean, so one... Well, put it this way, there are a number of...
Just give me the reference, or rather...
I'm afraid it is not... It's not reported, and that's why we... But it was the first case in which a constitutional remedy was granted on that basis.
Is there really any problem of inconsistency with Hunt? What was being... The argument there, what we were looking at there was a precedent in Matthew, which said that on a criminal appeal, the board could fix a sentence under using the jurisdiction conferred by section 14(2), and the court was saying in Hunt, no, we can't alter on an appeal a sentence that was perfectly lawful when it was imposed, and the existence of jurisdiction under section 14 doesn't alter that. Now Mr. Knox doesn't contest that jurisdiction exists under section 14. The power is wide enough, but his argument is that the court wouldn't ordinarily exercise that jurisdiction if it would cut across the power which the Constitution confers on the President.
Well, my lord, first of all, there is that power. Secondly, the existence of that power was the reason for saying there is a remedy, therefore don't do it yourselves on a criminal appeal, not don't do it yourselves because there's a remedy in the commutation power, but because there's a remedy by way of constitutional motion. Thirdly, I think in the Walker case, that was what was said in Walker, that if you want to complain about delay in the individual cases, seek constitutional motions. So in the Walker case in Jamaica. Yeah. And so, my lords, not only is there the possibility of doing it, it was envisaged as the norm, as the relief, not, and quite rightly we say, because if there's been a breach of constitutional rights, the normal remedy is to seek a remedy in the court for the breach of your constitutional rights, and under 14.2 there's an established jurisdiction to substitute, as Pratt and Morgan said, the sentence which is appropriate.
Yeah, no, we've got that. What I was after was finding out whether there's any evidence, evidence in the loosest form, of practice of doing it. Now, I have found Thomason.
Yes, thank you, my lord.
No, my fault. Thomason Paul.
Yeah, yes, sorry, my lord.
And actually, that doesn't help on this, because the judge, having spent 20 or 30 pages concluding that the death penalty had to be, he had to be relieved, they had to be relieved of the consequences of the death penalty, effectively declined to substitute a life sentence because he thought it might well be too short, and instead ordered detention during the President's pleasure, which effectively passed the King back to the executive.
Well, but it's an order of detention.
Yes, but what I'm after is whether there's any material of the demonstrating that a practice has developed in Trinidad of the court dealing with these delay cases by way of constitutional motion and substituting another sentence. It may well be that there isn't, simply because the President always gets in first.
Well, my lord, I think there are, but my lord, obviously we'll provide you with them. But what Hunt and Khan is definitely decided on the basis that that is available. Yeah. Pratt and Morgan is decided on the basis not only it's available, they're going to exercise it. And you've seen the cases in Belize where that's been done, and you've seen also the case of Abraham, where it was done that was done in the exercise of the sentencing, but it was done under 14.2 still. It was done under 14.2 because they were saying we can exercise 14.2 in a sentencing.
We haven't got Ramdeen, the decision which was overruled in Hunt, have we, in the papers?
No, my lord, I don't.
It's quite interesting. I was just looking at it here.
Yes, my lord.
The dissenting judgment which I gave with Lord Sumption, which effectively prevailed in Hunt and Khan. Yes. Says the applicant's remedy to ensure that the death sentence was never implemented after the 5-year delay was to seek to have her sentence stayed and commuted or remitted by the President under Section 87.2 of the Constitution, or if necessary, to apply it first instance to the High Court under Section 14.
Yes.
And then it goes on to discuss how Section 87 to 9 works, and then should relief not be forthcoming in this way, the remedy is to apply to the High Court under Section 14 and sets that out.
Yes.
No one suggests, and you were in the case, that these remedies involving applications to the President or the High Court are not or would not be complete. Indeed, no one's been sentenced to death has been executed in Trinidad and Tobago since July 1999. Well, so, I mean, it does seem to have been uncontroversial in these cases.
No, not complete, not to stop execution, I accept that, my lord, but my respectful submission would be that it was there recognised that there was a remedy by way of constitutional relief, such as was given in Pratt.
If necessary.
Yes, if necessary, yes. But, my lord, in this case, well, your lordships have our submission, it is necessary because there has been a defeat of justice in the first case. But, my lord, I do submit that that actually makes my point about it's not extinguished. Because if necessary means even if the President does it and does it imperfectly, you have the unextinguished right to apply to the Constitutional Court for the relief. And my Lord, we do respectfully submit that that's the case. And my Lord, what's significant about the Trinidad Constitution, can I take you to section 14, is that many other constitutions expressly say you don't have this right if you've got a remedy under an other law. They don't say that in section 14.
Well, doesn't it say so? I thought that was drawn to your attention by Lord.
No, it says without prejudice to any other action, not
yes.
that the other. So, in other words, this doesn't
exclude it. You say
exactly, my Lord. What it's saying is, you don't take this as removing your normal common law rights. This is very much, if I can respectfully say so, my Lord Reid's point about remedies under the common law. The fact that you've got the Human Rights Act doesn't mean it's extinguished your common law rights. They still there and probably ought to be used in many cases. In the case of the parole board case, my Lord, Osborne. That's all that says. Now, what's significant, and this is why there are much more constitutional motions in Trinidad than other jurisdictions. In other jurisdictions, they have a 14 free, or a whatever it is free, sometimes 20 subsection free. The court can decline to give relief if they're satisfied that you have a remedy under any other law. Now, it's significant that that's not there. And remember, this was a carefully thought out constitution with all those Trinidadian jurists having input into it. It's highly significant that it simply says the fact you've got 14.1 doesn't mean your common law rights are extinguished. But it doesn't even give the court a discretion to say we're going to decline because you've got a remedy under another law. Isn't
that the normal principle, that you don't seek a constitutional remedy if there is another available remedy?
Well, actually, in Trinidad, you usually seek both because of the plenitude of remedies under Section 14.1. Very often, people will bring dual applications because the remedies are greater.
But still, the general principle which the board has laid down is that constitutional remedies should be of a last resort.
Yes, but my Lord, but what one's looking at then is an alternative. In my respectful submission, is an alternative legal remedy,
Yes, well, I
not a mercy remedy, which has no parallel. So, my Lord, and there we come back to Lord Bingham dealing with mercy. Mercy is a separate exercise from the enforcement of rights or the giving effect to rights. And right back to Lord Diplock saying in De Freitas and Benny, mercy begins where legal rights end. Now, the fact that we have now provided for judicial review of mercy doesn't mean that it's not in the category of a residual long stop way of remedying an injustice when the legal system fails. And that's quite different from the right to invoke a legal remedy through a constitutional motion. So, my Lord, that's why I say it's not extinguished, and that's why I respectfully submit, and your Lordships have heard me in some detail on this point, that despite what my learned friend says, there is nothing in section 14.1 which indicates that the existence of the commutation process means that it's the prior or natural remedy, and where someone wishes to invoke this, even we respectfully submit after they've been given an imperfect remedy or a perfect alleviation of their situation under section 87, it's not ousted. And my Lord, that is our submission. And the fact that the Chief Justice has given his imprimatur to a sentence we respectfully submit, again, does not mean that cannot be set aside and a fuller remedy accorded. My Lord, that's our submission about the fact that the effective remedy survives. And my Lords, of course I accept that our position now is a modification of the position that was advanced before the Court of Appeal. But I hope that moving towards a more moderate position rather than towards a more extreme position is precisely what the legal process is supposed to promote. That's to say, oh, I see that that's unarguable, but this is this remains an important point. But I mean, that's the dialectic of forensics. And so my learned friend's saying, oh, that's not what they argue below. No, well, one can be enlightened by the process, and indeed by my learned friend's brilliant arguments to say, well, this is really the point that one should be taking. And my lord, I hope that the forensic point can be made that it's different than what was argued below, is not a point to say that it's therefore without its validity once it's taken. My lord, the Chief Justice point, I don't really,
Section 70, yes.
Yeah, well, my lord, can I just, of course, my learned friend's absolutely right. If one was conducting a conventional exercise of statutory construction, we wouldn't have a hope, if I can put it that way.
You've got to learn to fly.
You've got to, and that's what, and can I just give you the reference? It's in Mollison, where Lord Bingham, that's the one which authorises the substitution of court for the executive, says, he cites a judgment of, I think it's Justice de la Bastide, in which he's saying it's a totally different exercise. Perhaps I should, it's Mollison.
Is it the one, the unlimited power one, and Lord Bingham saying there's a very wide power?
Well, my lord, it's slightly different. It's volume 7, tab 10. He says the word construed with modification.
Yes. It's that element.
Yes, it's it's page 221 at 427C.
It's sentences on young persons, isn't it?
Yes, yes.
And whether they can properly be during the president's pleasure, or you must substitute
Court.
Yes, but it's in the context where existing law was saved.
Quite.
So it was a sentence that existed at the time of independence and would be saved unless you could interpret it. So that's why
it's done by interpretation.
Yes, and so then one sees the quotation from Chief Justice de la Bastide, having made this, we are now in a position to assess the purpose and effect of section, that's the modification power. And the first thing we can say, the section is for being the type of construing which involved is not the examination of the language of existing laws, nor is it attributing to existing meaning which, though not their primary, is one which they are capable of bearing. In other words, in fact, the function which cause mandate to carry out in relation to existing laws goes far beyond what is normally meant by construing. It may involve the substantial amendment of laws, either by deleting part of them or making additions to them or substituting new provisions. So it's a very extensive power, and it's a powerful power under the Constitution. And in Matthew, there's in the dissenting judgment of Lord Bingham, there's a very scholarly summary of how extensive that power is, which I just respectfully commend to...
Well, it's the same, isn't it, a similar part of the one that we have under the Human Rights Act or European law?
It's stronger, because we're told that you shouldn't do more than...
Well, we have added in words.
Yes,
we have
yes, but it's a very powerful...
deleted words, and we can't go against the grain of the legislation.
Yeah, well, except if you look at how they interpreted Section 30 of the Criminal Justice Act, it says you can be relieved on grounds of compassion, which normally means let you out because you feel sorry for them. Yeah. And now it's become if there's no legitimate penological grounds for your detention, which is completely different.
So
but if you
are
could read...
accepting my point.
Sorry, my lord, I am accepting. But if McLaughlin's rightly decided,
Right.
and they never let it get up to the Supreme Court because they didn't give a certificate. But my lord, but my lord, what I do respectfully, yes, it's a very powerful power. So it would, in our respectful submission, be sufficient to read in the word appropriate or not cruel and unusual, or provided it's the punishment that you're recording is not cruel and unusual. I.e. some limitation. But my lord, that's the argument. But what I reject totally is my learned friend's classic literal construction exercise, and then look at the history, look at the... That's not what constitutional modification is about in our respectful submission. And there is 3 decades of authority to that effect from all the different jurisdictions in the Caribbean.
Mollison was a case in which the muscular approach to construction, which you recommend, was being applied to legislation on the ground that without it would be inconsistent with the Constitution.
Yes, yes. Well, my Lord...
that wouldn't authorise the adoption of an equally muscular approach in applying the Constitution itself.
Well, if you're stopping a cruel and unusual punishment being imposed, my Lord, then it is giving effect to the Constitution. I mean, what the Constitution doesn't say...
You're interpreting, you say, the Criminal Procedure Act, really, aren't you?
Yes, yes, but yes, yes, exactly. What the Constitution doesn't say is that the President can impose a substitute penalty which is cruel and unusual.
I think we've got your...
If he said, I'd sentence you instead to be flogged in the days when corporal punishment was still allowed for, that might well violate the cruel and unusual prohibition if it was grossly inappropriate. My Lords, the cruel and unusual point, I respectfully submit, is not academic for the reasons. And can I just try to summarise what we say is the reason why, if the Court of Appeal upheld these sentences as capable of being, or of not being unconstitutional, and what the 75 years and the life interpreted as they interpreted it. My respectful submission is, if it's upheld, there are 2 significant points about the way sentences of that length, if imposed, would be cruel and unusual. Firstly, there need never be a consideration of what period of time is merited as punishment if life is given, because you just give life and leave it to the executive, and the executive doesn't have to consider at any point, because there's no requirement for them to consider whether the period that, say, Norbert Williams has served for his offence under some provocation has now exceeded the period merited as punishment, because the presumption is that life is the punishment. And we respectfully submit that that's cruel and unusual. And the second point is because there is no point at which the wider determination of whether continued detention is justified on penological grounds has to be carried out by the decision-making body itself, that's to say the advisory committee. And we say, my learned friends, quite right to point to the apparent humanity and concern of some of the reviews one sees conducted internally by the prison. But they don't carry through, because they then have to go up to the commissioner, who in one case we saw vetoed for a purpose. They then have to go up to the advisory committee. The advisory committee has to advise the national security minister, and he has to accept their recommendation. So he's the effective decision maker. And unless there's evidence that he is governed by clear and accessible criteria, it's our respectful submission that then the test of whether there is a penological justification for continued detention is not met. Now, my learned friend says, oh, you can't really get that out of the European court cases. I've shown your lordship those words occurring time and time again in the decisions of Vinter, in the decision of the Bulgarian case of TNP, in the case of Magyar in Hungary, in the second Grand Chamber decision of Murray. It's a clear and consistent case law that that's the minimum requirement, that there be, by the decision maker, a review of whether the continued detention is penologically justified. And then, in case it's said, well, this is just some foible of the European Court which shouldn't be transferred to the minimum requirements in Trinidad, I make these points. Firstly, those cases were decided in cases of the utmost gravity where there had been, in some of them, a discretionary exercise of this by the judge. This is so bad that I, taking into account the gravity, say the person should have whole life. If that standard applies there, in Europe, then we say at least it should apply to the common or garden murder case in Trinidad. It's the minimum requirement in the case of a mandatory imposition of the death penalty, that there be some review at some stage, we say at least after 25, perhaps after 15 years, of whether continued detention is penologically justified, and that test be clear and accessible to the prisoner. And we respectfully submit that at the moment it is not laid down, it is not clear and accessible, and indeed, by its very nature, jurisprudentially, the mercy exercise is not governed by any criteria. It's a pure present, as it were. Now, and Neville Lewis institutes procedural grounds and suggests that there could be substantive review if the decision was perverse, the kind of red-haired case example. But it doesn't suggest that the courts could be imposing criteria. My lords, we say that in the exercise of the constitutional power to protect against cruel and unusual punishment, this court could declare that certain minimum tests have to be applied.
Yes. I mean, what about the basic or the starting problem, which was Mr. Knox put, that it wasn't argued like this before. We haven't really got the court's view below. The argument was put on a different basis, that the particular reviews weren't being implemented properly.
Well, my lord, if this is the minimum requirement,
we should state,
and you declare it, and they've been doing it all along, they'll have nothing to complain about. Yes. If it's the minimum requirement and they have not, and they haven't been doing it all along, then they ought to be. So I don't see, I mean, but in any event, my lord, there was the issue below was what kind of reviews are there? And Mr. Edwin Grell repeatedly described the whole system. He went through. It starts off with the prison review, it goes to the commissioner, it goes to the advisory committee. This is how they look at it. Yeah. I mean...
All right, well, I think we've got your point.
Sorry, my lord. Well, then...
And, now, what other points have you got to deal with? Because you indented for half an hour, we've had 55 minutes.
Oh, sorry. Well, no, those, my lord, that's my corner. And I'm sorry, those are my...
Don't worry, it's an important case, but
no, my lord,
want to know how much more.
No, those really are my points. I mean, my learned friend's restrictive reading of Vinter, I say, ignores in paragraph 119 and 122 the words a whole life sentence prisoner is entitled to know at paragraph, and the words about no longer justified on legitimate penological grounds. In other words, there is a test.
Yes.
And there is something he's entitled to know.
Yes.
And my learned friend just saying it's got to be reducible in some way or other is, with great respect, not enough.
Well, he says that's what the focus was on below, and we'll say whether it was or not, this is the time to at least restate some general principles.
Well, my lord, also, I do invite the board to look at the passages I've cited from the 4 successive cases, including 2 Grand Chamber cases, and indeed Hutchinson, the second time round, that they have repeatedly re-emphasised the clear and accessible criteria, and there must come an identifiable point around 25 years. I think in a French case they said it could be up to 30 years, but if it's 40 years it's been said to be too much in some other case. But I mean, certainly, we respectfully submit the Rome Statutes there, it's been signed up to by more countries than almost anything else has been signed up to, apart from America, of course. But I mean, the Trinidadian input into that was massive, and 2 of the Trinidadian judges, one of them's the president of Trinidad at the moment. President Corona was a judge. I mean,
I think he's been in the press.
Oh yes.
Quite recently.
Yes. But all I'm saying is there can be no accusation of, and I know it was only meant in the context of toing and froing being colonialistic, but there can be no. That's signed up to by countries throughout the world. And your lordships have our point also that if there is any timidity on the basis, well, are we imposing something which is inconsistent with Caribbean practice? The Caribbean practice where the death penalty cannot be mandatory and where the sentence is at large for murders of comparable gravity to many of these cases indicates that fixed-term sentences in the region of 20 to 30 years are regarded as appropriate in other jurisdictions in the Caribbean. And so it would not be relativistic, imperialistic or whatever to say we can see that this leaving someone completely at the mercy of the state for the whole of their lives without a clear and accessible criterion in all cases of murder where it's the life sentence is substituted for the death penalty would be, we would respectfully submit, entirely consistent with the practice throughout the Caribbean and indeed in Trinidad itself in those cases where there was the power to declare a minimum term. So, my Lord, that's my respectful submission in relation to that. My Lord, I'm sorry, my Lord Sumption, I don't know whether I really answered about the cruel and unusual. All I respectfully submit is that there are circumstances contemplated by Weems and indeed cited in Bow where a grossly disproportionate penalty which failed to take into account the individual circumstance of a case could be a cruel and unusual punishment. Indeed, the whole thing of that Granucci article about the original meaning of cruel and unusual is that right from the time of Titus Oates, it did carry the notion of a disproportionate penalty as well as a cruel one. It's not just the flogging, but it was regarded as grossly disproportionate.
Must be a distinction, mustn't there, between constitutional breaches which reach that standard and failure properly to treat people in prison? Or is every failure to treat someone in prison properly necessarily a cruel?
Oh no, but a penalty which is imposed, a penalty such as life or 75 years, which is imposed without regard to individual circumstances and is massive, can be so grossly disproportionate as to be cruel.
See that argument.
My Lord, that's our respectful submission.
Thank you very much indeed.
Oh, and my Lord, I've taken your Lordship's points on board. I'll try to make sure that all the second thoughts are had before the cases. My Lord, I'm not being flippant. I see what's gone wrong.
Well, I think in this case it was particularly difficult for everyone all round, and thank you very much for that assurance. And I will, in turn, like to just apologise to Mr. Delzin for not calling on him after Mr. Fitzgerald, after your leader opened the case. But, pleasure to see you here anyway. And the board, yes.
One point. I don't know if Mr. Fitzgerald is running this point, that in deciding the cruel and unusual point, you're entitled to look at the individual facts now of what he produced yesterday, of the individual cases.
Yes.
My Lord, I certainly resist any such notion. That was not how the case had been presented. In other words, it was never said below, well, look at my case. That's completely disproportionate. That's never been an issue at all. I
think he's only really saying that illustrates the fact that they differ.
My Lords, there's no doubt they do. I'm not opposing that point. If it's used for that purpose, I have no objection.
Yes.
But I do object if it's taken any further.
It's the lack of individual consideration, my Lord.
Well, the board is very grateful to counsel on all sides, both sides, for their submissions, and will take time to consider its judgment.